The concern is about the Cabinet's power to rescind, with no need to justify, people's existing rights, water rights, development rights, resource extraction rights. That's the concern. So whether or not some other legislation has a process is irrelevant. The question is, does this legislation create a clear entitlement to compensation? They made no change in the area of entitlement to compensation if your water rights and resource user rights. They've created a confusing provision that might create some compensation if the Cabinet restricts your use of your land. But that's as far as it goes.
Prior to the program, Keith, I actually looked over a list of some of the proposed amendments, and I noticed that there's a reference to the fact that the new bill, it indicates that the rights of individuals must not be infringed upon except to the extent, this is not a direct quote, but the words that I read were to the extent necessary. It's not a complete quote, but it said to the extent necessary for the overall greater public interest. And as soon as I read it, I asked myself if the greater public interest was ever defined or is ever defined in the bill. Is this a significant thing for me as a property owner or landowner?
You nailed the words exactly, actually. I'm looking at them right now, and the phrase you used is correct, to the extent necessary for the overall greater public interest. Let me explain what that section is. It's a purpose statement. It's not a statement that grants substantive rights or powers. What it is intended to do is to guide the interpretation of the legislation. And so what it's essentially saying is, on the one hand, the legislation shouldn't infringe, but on the other hand, if the Cabinet thinks that it should, and the Cabinet thinks that it's in the greater public interest, the Cabinet can do it. And that's exactly the substantive powers they've given themselves under Section 11. People really need to understand that Section 11 is unprecedented powers in the Cabinet. And here's an example that I could give you. Imagine driving down the road and a police officer pulling you over and asking you for your driver's license and just saying, I'm taking it. Not to write you a ticket, just because they're taking your driver's license away. And you say, why? And he says, because I can, and I am. Now go phone a taxi, we're towing your car, I've taken your driver's license. Well, that's outrageous, right? Well, that's exactly what the Cabinet can do with your water license, your mineral lease, your grazing lease, your development rights. Section 11 says they can rescind your permit, your license, your approval whenever they want.
Under the original Bill 36, they would extinguish your license. So if the police officer took my driver's license away and said, I'm extinguishing it, that would be the situation under the old bill, and that under the new bill, the same police officer would take away my license in exactly the same way, except instead of telling me that he's extinguishing my license, he would say to me, I'm rescinding your license and you can't drive a pickup truck or a car anymore.
That's correct. By analogy. I'm using an analogy to get people to understand how broad it is. But let me make one point clear. They have improved the Act through 2 amendments where they've made it clear that power of Cabinet to rescind does not extend to a land title, and it does not extend to an existing development permit if you have actually started construction on it. But and that's a good improvement, make no mistake. But as I emphasized to the minister, the concern, of course, people were very concerned that the Cabinet had given itself the power to extinguish or now rescind a land title. That's good that they've taken that out. But there's equal amount of concern. When you get into southern Alberta, your water right in some cases is more important than the land title. It's the water and the irrigation rights and the water license that creates the ability to generate wealth and add value. So, and if you can imagine, if you're an oil and gas company, how important your crown mineral lease or a forestry company for your forestry timber license. So, it's good that they've taken away that power with respect to a land title, but it still exists with respect to all of these other areas.
Is there provision in the new amendments is there provision for an appeal process, Keith, like to some type of board, or, if Cabinet makes a decision about my property or the property of a listener, what might the appeal process be?
They have created an appeal process, and it's puzzling to me. They've created an appeal process where you can basically appeal to the minister, and the minister gets to appeal or gets to appoint the judges. So you're not the judges; they get to appoint the appeal board members, and then the appeal board reports back to the minister. Then the minister reports to Executive Council, which is a division of the Premier's office, and then they report to the Cabinet. And it's not clear at all what powers any of them have. And you say to yourself as a lawyer, well, why are they doing all this? We have these things called the courts. We have under our constitutional system, we have superior courts, meaning judges appointed by the federal government. And they hear complaints from citizens against the provincial government. You follow me? It creates this impartiality, independence of the judiciary. And I'm not saying every decision of every court's fine and without criticism. Absolutely not. But the important thing is we have this mechanism. We have this mechanism through which we adhere to the rule of law. We keep government's powers in check. We ensure freedom of citizens and democracy through creating access to the superior courts where you feel a government through its actions has unfairly or improperly taken your rights. And they are so steadfast on not going there. And that's truly troubling to me, and I think many Albertans, that number one, they would give themselves these powers, and number two, they would take away the traditional rights that people have in terms of access to the courts.
One of the things that struck me when the National Energy Board made the decision to transfer the Nova Gas pipeline system in the province away from provincial jurisdiction and into its own regulatory portfolio, it expanded the size of its own regulatory regime, the number of kilometers that it regulates, of pipelines it regulates in Canada. It expanded that by 50%. And in that situation, what happened is that the National Energy Board bureaucrats were the judges in the decision and the beneficiaries of their own decision, because the minute they made the decision, they had to expand their budget and their numbers of employees. And in fact, just a few days after that decision was made, the senior official at the National Energy Board referred to the decision as priceless. And when I saw it, I thought to myself, what judge in any fair-minded regime would refer to his or her decision about anything as priceless? And in that case, the National Energy Board CEO, he didn't say that it was a good decision, a right decision, a fair decision. He referred to it as priceless. And if I hear you correctly, Keith, and clarify me if I'm wrong, because I don't have the legal background you do, but if I hear you correctly, you're saying that under the new Bill 36 proposals, that the cabinet minister would make a decision and the landowner would have a right to appeal that decision, but he would effectively be appealing it back to a board that was still effectively controlled by cabinet or by the Premier's office. Am I hearing you correctly?
Yes, and yes. You would appeal to the minister. You would appeal the cabinet decision to the minister, who would select 3 people of his choosing to hear your complaint. Those 3 people would make a report to the minister that he would send to the Premier's office, which would ultimately go to the cabinet. I mean, come on. That makes no sense. One of the things, the discussions I had with the minister, and Dave will recall this, is, I explained to him this principle of the rule of law, because we often hear it, and we often don't pay attention to what it means. And it means that the court is there as an arbiter, and it dates back to the Magna Carta of 1215. And the court is there as an arbiter to keep governmental decision and powers in check. And if a citizen feels aggrieved by a governmental decision, they have the right to go to court, and the judge in that court has the power to overturn the government decision. And I pointed out to the minister, I related to him watching the press conference with Prime Minister Harper and President Obama about 3 or 4 weeks ago now. And you remember when the Prime Minister was down in the United States, it was right in the midst of the Egypt crisis, when it was at that tipping point. Nobody knew whether it was going to be resolved peacefully or whether it was going to turn into another Tiananmen Square, bloodbath. And in that press conference, I remember clearly both President Obama and Prime Minister Harper urging the Egyptian government to move to the restoration of the rule of law. And I said to Minister Knight in his office on Monday, I said, I urge you to restore the rule of law in Alberta. And I know that may sound dramatic, but it's true. These mechanisms that they've put in this legislation, as has been described by another law professor from Calgary, are, in her words, draconian. And I believe that's an appropriate word. This is serious stuff. Now, in the spirit of describing the amendments fully, they did make an amendment with respect to citizens' right to go to court, and it's in section 2.1 if somebody's interested in looking it up. But it's what's interesting and revealing about it is what they've done is the original legislation said no one basically had the right to review any decisions of the cabinet. Their public policy decisions, the cabinet has exclusive final jurisdiction, no court has jurisdiction. Then what they've added a section is saying, in making a regional plan, the cabinet can decide which of its decisions it says all cabinet decisions are not subject to review by a court unless the cabinet says some of its decisions are. So the cabinet now has the choice to take some of its decisions and say, well, this one could be reviewed by a court if somebody doesn't like it. That's not democracy. That's not the rule of law.
That would also mean then that the cabinet could take some of its decisions and say, this is a decision that could not be reviewed by a court.
The way they've written it is every decision is not reviewable. So the starting point is, and this is with the new legislation, the revised form.
We're talking about a decision by cabinet.
Yep. So every decision by cabinet is automatically not reviewable by a court unless cabinet declares that it is. So the default is no courts unless cabinet says, in this instance, we will let you review us. So if they say nothing, it's not reviewable by a court. If they proactively say, well, on these 5 decisions or this part of the regional plan, we'll let it be reviewed by a court, then it would be. And that, again, as I said a minute ago, is not democracy.
This program has been sponsored by CAEPLA, the Canadian Association of Energy and Pipeline Landowner Associations. CAEPLA is a non-profit association that is not underwritten or sponsored by any foundation or institution, nor do we accept grants from the government. As a non-profit organization, we rely entirely upon the voluntary support of people like you who think this kind of thoughtful and informative approach to landowner issues is valuable. So if you think this kind of programming is worthwhile, we invite you to go to landownerassociation.ca on the internet. Click the icon on the navigation bar that lets you take out an associate membership or make a donation, and then just simply follow that through. The website is encrypted and secure, so you don't have to be concerned about the safety of your credit card or bank card information. We'll end the program this week by leaving you with the words of Walter Williams, an award-winning economist at George Mason University. He said, if we buy into the notion that somehow property rights are less important or are in conflict with human or civil rights, we create false distinctions and play into the hands of those who seek to control our lives. That's it for CAEPLA Connections Landowner Talk Radio. We'll see you next week at the same time.